Hello, law students and legal practitioners. Today, we will discuss the case in the matter of Populus Lending Corporation, also known as PESOPOP, and its responsible officers, docketed as NPCSS case number 21-008 and decided by the National Privacy Commission in 2023. Let's begin. Here are the doctrines of this case. The compulsory collection and processing of a borrower's entire phone contact list by an online lending application, without a valid lawful basis, violates the Data Privacy Act of 2012 and constitutes unauthorized processing under Section 25, even if labeled as consent-based. Consent obtained through bundled, coercive, or misleading app permissions, where denial prevents access to essential services, is not freely given nor informed and therefore invalid. Legitimate consent requires that data subjects are clearly informed of the specific, limited, and lawful purposes of processing. The principles of transparency, legitimate purpose, and proportionality continue to apply regardless of the asserted lawful basis. Processing that violates NPC Circular No. 2001, loan-related transactions, including harvesting contact lists for debt collection, is per se unlawful, renders the processing illegitimate, and exposes both the corporation and its responsible officers to criminal liability under Section 25, in relation to Section 34 of the DPA. Repeated defiance of a temporary ban on processing of personal data constitutes further unauthorized processing and supports a recommendation for criminal prosecution. To clarify the issues, here are the relevant facts to the case. The National Privacy Commission, NPC, through its Complaints and Investigation Division, SID, initiated a sua sponte investigation against Populus Lending Corporation, operator of the online lending application PESOPOP, following numerous reports of abusive and privacy-invasive practices by online lending apps. Upon simulation and technical examination of the PESOPOP app, the SID found that users were forced to grant access to their entire phone contact list, storage, location, camera, and phone state as a mandatory requirement to proceed with loan application. The app provided no alternative interface allowing borrowers to manually select character references. PESOPOP's privacy policy contained conflicting and misleading statements, declaring that data would be used only for credit review, but later asserting the right to access and use contact information, including social media accounts, for debt collection. The policy failed to clearly specify retention periods, automated decision-making logic, data subject rights, and safeguards required under the DPA. The SID found that PESOPOP's practices violated Sections 11, 16, and 25 of the DPA, as well as Section 3, D, 4, of NPC Circular No. 2001, which expressly prohibits access to phone contact lists for debt collection purposes. On the 12th of August 2021, the NPC issued a temporary ban on the processing of personal data, ordering PESOPOP to stop processing and to take down its app. Despite repeated orders, PESOPOP re-uploaded and made the app available multiple times during the effectivity of the ban. Let us now determine how the National Privacy Commission resolved the following issues. Issue 1. Whether PESOPOP committed unauthorized processing under Section 25 of the Data Privacy Act. Yes, PESOPOP committed unauthorized processing. Section 25 of the DPA penalizes the processing of personal or sensitive personal information without consent or without lawful basis. PESOPOP processed personal and sensitive personal information, including users' phone contacts, birthdays, location data, and other identifiers, without valid consent and without lawful basis. The forced access to phone contact lists violated the principles of legitimate purpose and proportionality and contravened NPC Circular No. 2001. Consent was invalid because it was bundled, misleading, and coercive, effectively forcing users to agree or be denied loan services. Issue 2. Whether PESOPOP's processing violated NPC Circular No. 2001, loan-related transactions. Yes. PESOPOP violated NPC Circular No. 2001. Section 3, D, 4, of NPC Circular No. 2001 prohibits online lending apps from requiring access to contact lists or harvesting contacts for debt collection. PESOPOP required access to users' phone contacts as a condition for loan application and failed to provide a separate interface for character references. Its privacy policy explicitly allowed using contacts for debt collection, a practice expressly prohibited. This rendered PESOPOP's data processing illegal and illegitimate. Issue 3. Whether PESOPOP validly relied on consent as its lawful basis. No. Consent was invalid. Consent under the DPA must be freely given, specific, informed, and evidenced. PESOPOP's consent mechanism was coercive and uninformed. Users were not given a real choice, as denying permissions prevented loan access. The privacy policy's contradictory statements further prevented informed consent. Consent obtained under these circumstances is legally ineffective. Issue 4. Whether repeated violation of the temporary ban constituted further unauthorized processing. Yes, repeated non-compliance constituted continuing violations. Processing personal data during the effectivity of a lawful temporary ban lacks any legal authority and constitutes unauthorized processing. Despite repeated NPC orders, PESOPOP republished the app multiple times. Evidence from Google and the FTC showed tens of thousands of downloads during the ban. These acts demonstrated willful and continuing violations. Issue 5. Whether PESOPOP's responsible officers may be held liable. Yes, responsible officers are liable under Section 34 of the DPA. When the offender is a corporation, criminal liability is imposed upon responsible officers who participated in or allowed the violation through gross negligence. The board and officers authorized app relaunches and revisions despite the ban, or failed to prevent repeated violations. Their acts and omissions constituted participation or gross negligence, warranting criminal prosecution. That's all for today. Thank you for listening and happy learning. See you again for our next case discussions.